This video is made possible by Practical Defense Systems, the best online security training at the lowest prices. You can start your security career today online at pdsclasses.com. Check them out. Hi, I'm Joel Persinger. I'm the Gun Guy. Thank you very much for all of your support of GunGuyTV. I am super duper grateful. A couple of quick points before we talk about the incredible victory we've had in New York, in which Gun Owners of America has smacked down New York's new concealed carry law on their way to a great victory coming up when it's wiped out entirely. We'll talk with Sam Paredes, who is not only of Gun Owners of California, but also he is part and parcel of Gun Owners of America as well, and he'll give us the nitty-gritty on that. If you would like to support GunGuyTV, you can do that by joining GunGuyTV Crew. I will put a link in the description, or you can just go to GunGuyTVCrew.com. That's where you can best support me. Also, check us out on these alternative locations, because there's a lot of places that we post videos that are not YouTube, and sometimes YouTube does not like the videos I post, and they delete them. Doesn't happen a lot, but it does happen periodically. One way or the other, you'll always find them on these alternative locations. You'll notice we added Twitter in there, because since Elon Musk has purchased it and promised that it will have a robust video posting component for creators, I figured, what the heck, I'll join. So I signed up for Twitter. You can find us there if you'd like, and follow me over there in preparation for freedom on Twitter, hopefully, and another free place to post videos for GunGuyTV. I'll put a link in the description. All right, let's go talk to Sam. Sam, thank you very much for joining me today. This is it's a great day. I mean, it's election day, first of all. You know, I was looking at Rick Grinnell's Twitter feed today and seeing some of the things he's doing, and it just looks like it's going to be a great turnout for the election today. And at the same time, the problem with all the election coverage is something happened yesterday that sort of got swept under the rug and nobody's talking about it, and that is that Gun Owners of America had a huge win against New York. So I wanted to have you come on the show and tell us about that. But before you do, I want to show my support for Gun Owners of California and Gun Owners of America. Well done. All right, so what exactly was the victory yesterday, and what did we achieve?
Well, Judge Sotheby, who heard the case of Gun Owners of America versus New York, originally he declared that the lawsuit was invalid because we didn't have standing. So when he refused to proceed with the case, he said, I can't rule on this, but there's no, it's without any prejudice. So we went back and we got Gun Owners of America members in New York who were definitely affected by the so aptly misnamed and almost cynical Concealed Carry Improvement Act that was passed by the legislature in New York in an emergency session and signed by Governor Hochul. The judge said, yeah, you don't have standing, but if you did have standing, I would have declared the vast majority of the new law as unconstitutional. So we went back to work, immediately identified some GOA members who absolutely had standing, refiled the case. Judge Sotheby took the case, and when we submitted it, he issued a temporary restraining order, which said that the CCIA could not go into effect while he considered the case. Well, subsequent to that, he issued a preliminary injunction, which means that this is completely suspending the CCIA, or the vast majority of the CCIA in New York. And that's a beautiful and amazing thing. And when he was asked by New York to issue a stay on his preliminary injunction for 3 days so they can go to the Second Circuit Court of Appeals and ask for for relief, the judge said, no, I'm not going to do that. This is unconstitutional, and my preliminary injunction stands. So,
you know, I got to tell you, Sam, before you continue, I was so overjoyed by that, because so often judges let this stuff go by. And, you know, the old saying, a right delayed is a right denied, is very true. And this judge seems to understand that. So he refused to let it just sit denying everybody's rights while this works its way through court. I hope that stands. But anyway, I'll let you continue. I just wanted to comment on that
and
because
what you said is
huge.
absolutely correct. The judge said that even denying New Yorkers their rights for 3 days is 3 days too much. And that's one of the rationales that he used to not issue a stay on his own ruling. Now, what does this mean? Well, he pointed out unprecedented constitutional violations. So this is what he suspends. The whole requirement for good moral character, gone. Requiring names and contact info of spouses and other adults in the applicant's home, gone. Requiring applicants to disclose social media accounts for review, gone. Restrictions on carrying in public parks, zoos, places of worship, locations where alcohol is served, theaters, banquet halls, conferences, airports, and buses, lawful protests or assemblies, and the prohibition on carrying on private property without express consent from the owner. These are all gone. Now, especially those folks who are from California, this sounds rather familiar under the guise of SB 918. Pretty much all of these things were included. The judge went out and plainly and clearly said that banning lawful concealed carry in places like Park Avenue and all of the zoos and the restaurants and all of these places are clearly unconstitutional. So huge victory. New Yorkers who have concealed carry weapons permits can actually use them and carry firearms in all of these places. This is a massive victory, and it happened because of the grassroots support of people throughout the country who have supported Gun Owners Foundation, Gun Owners of America, Gun Owners of California, that gave us the financial resources to be able to bring this case to court. And we are smashing a tyrannical government. New York, the governor is a tyrant. She, in essence, says, I don't give a flying flip what the Supreme Court says. We are going to do what we are going to do because we are New York. Same thing that the chairman of the Public Safety Committee in California said when I testified on a bill and said it's unconstitutional. He said, well, we don't pay attention to the Constitution because we're California and we do what California is going to do. Well, that's coming to an end. This is, we are now in a unique situation. New York, which we expect, is going to appeal this to the Second Circuit. If it goes to the Second Circuit and if they rule in our favor, along with Judge Sotheby, well, that creates a precedent for the whole Second Circuit area, all of the states that are within the Second Circuit. And now that argument has weight in cases throughout the country. Now, it doesn't mandate that the other circuit courts have to follow this, but now they have to argue against this. Now, if they rule against us, and then along with supporting Governor Hochul, then of course we have an opportunity to go to the Supreme Court. And now the Supreme Court has shown a willingness to not futz around with these types of cases. Instead of waiting and discussing and putting them in conference and deciding if they're going to grant certiorari, which means to accept the case and to hold the hearing on the case, they have begun to use more often this granting certiorari, vacating the ruling of the court that brought the case, and remanding the case back to them, saying, okay, knuckleheads, redo your thinking on this based on what we said in New York State Rifle and Pistol Association versus Bruin. So that's, Judge Sotheby quoted Justice Thomas over and over again, pointing out how, you know what, New York, you can't do this. You can't do that. You can't do any of this stuff. Now, this wasn't a 100% victory. There were some things like he let stand the 16-hour requirement for training. and some of the other minor provisions, but the vast majority of the Concealed Carry Improvement Act in New York is no longer in effect.
Now, Sam, is this is a preliminary injunction? Correct me if I'm wrong. My understanding is that this is a preliminary injunction to prevent the enforcement of the law while the case proceeds.
That's
this was
correct.
not the actual final decision after the judge has heard the case. Am I correct about that?
That is correct. After the case is completely gone through the process with Justice Sotheby, we are in hopes that he will issue a permanent injunction, and in that case, it's not temporary; it is permanent.
And
in
the meantime, I guess New York could try to take this to the Second Circuit to get them to do away with the preliminary injunction.
Yes.
Which is, I think, what they're planning on doing. They want to be able to enforce this law while it goes through court. And Judge Sotheby has said no, but they're going to try to go get the Second Circuit to waive that and allow them to enforce this while it goes through court. What do you suspect the odds of that occurring are?
Well, first of all, Joel, I've told you many times, shared with you that I am not an attorney. I did not go to law school on purpose, although I have been involved with gun control law since 1980. So in California, I have seen virtually every gun control law that has been placed on the books, come to passage here in the state. So know a lot about the law, understand a lot about the lawsuits. What I don't understand is the courts. Those are kind of like magical and mysterious things.
And I guess the reason I asked the question is because some of these courts obviously lean one way or the other.
No question.
And I don't know the Second Circuit that well, so I don't know how they've decided on firearms cases in the past, whether they lean one direction or the other. And I guess that's what I'm trying to get a feel for.
Yeah,
from you.
The Second has not been friendly to the Second Amendment at all. We anticipate that they're going to try every way they can to wiggle around this issue. But the guidelines and the fence posts that Justice Thomas laid out for the courts is so clear and so direct and actually so narrow that I find it difficult to conjure up a way that the Second Circuit is going to be able to rule against us on this issue. That's why we have seen in court cases throughout the country where Biden and Obama and Clinton appointed judges at the district level have ruled in favor of Bruin getting rid of assault weapons bans, large capacity magazine bans, age restrictions for buying guns. If you don't have a crime on your record, you cannot be denied your Second Amendment rights, even though you have an indictment against you. All of these types of cases, many of them have been ruled on by left-leaning anti-gun judges, and they do so with frustration, but they know that the guidelines are crystal clear. We have had one judge that said, I believe it was an Obama-appointed judge, he said, I'm not smart enough to rule on this issue. We need historians. I need to appoint historians to be able to find out if there is a historical analog to the gun control law that's before me and 1791. And basically said, even those boneheads on the Supreme Court are not historians. What he didn't say is that the Supreme Court said that you don't have to be a historian to know this.
No.
There's court precedent, there are court rulings, there are laws that have been on the books, and it doesn't take a rocket scientist to find out what those laws are. So they're wiggling and they're waggling and they're trying to go the long way around the barn, but they know full well that in the long run they are going to lose. So all of these are stalling tactics, and we expect that to continue for a while.
It's interesting that you mentioned the guideposts that the Supreme Court put in place, because this judge, actually, the three things I noted that he left in place, I think that I have right, are the requirement for reference letters or references from people that know you, that say you're an upstanding citizen or whatever. the training requirement, which you mentioned, and then the requirement to meet in person with the issuing authority. And it was interesting looking at, you know, in the brief time I had to kind of scan the opinion, because it's just been yesterday and I've been busier than a one-legged man at a butt-kicking contest. But I went through it and I found that he thinks he found analogs in 1777 and right around that area to support some of these three things. But what's interesting is a couple of the analogs, as far as I could tell, were about militia service. So, for example, the training analogs that he found was training required of militia members, not required of the average individual. So it's kind of interesting that this judge selected those. I see it kind of from two angles, and there's probably more angles than that. But one is I see a judge trying to find an analog to support the laws, but at the same time, I think I find a judge sort of setting us up for success, because we now know what the opposing argument is going to be, and we know what the analogs are going to be used for. Because, as I said, this decision was just to stay the enforcement while the case proceeded. The case has not proceeded, which means we look at this and we go, oh, those are the analogs you want to use? Okay, well, we can do some research and knock those out of the park. And I just thought that was a kind of an interesting aspect of the decision. I'm wondering what your thoughts are.
Well, the great point. First of all, Judge Sotheby, I think, is a judge who is evolving through this process. Remember, in his temporary restraining order, he allowed the banning of firearms in places of worship to stand. Well, there was another judge in New York on another case who found that to be unconstitutional, that there was no historical analog, that there were the occasions that were cited by the state of New York were actually outliers. And anybody who read the Bruin decision will remember that Justice Thomas and the other judges said you cannot count outliers as an analog, and they use analogs from places that were territories. They weren't even states. So you know there's a lot of stuff like that. Reference letters, that is not a objective standard. Somebody's going to have to read these letters and make a subjective judgment whether they provide the information that they need. So I'm not too concerned about that. You're correct about the militia service for 16 hours and you know, the requirement for training once a month with the militia for use in the firearms and stuff. You know, that is going to be so simple. If you remember that at the time of the Revolutionary War, people were coming with their own guns. These people were not going to a store and buying a gun and showing up for service with a gun that they've never fired before. No, they were using the guns that they have used to protect themselves, to hunt with and provide for sustenance for their livelihood, who made these guns many times in their own homes, or had somebody who was proficient in making these guns, build these guns for them, and then tweaking them for their own personal characteristics. It sounds like an AR platform to me.
Yeah, it kind of does, doesn't it?
So that argument, I think, is going to be addressed when this thing goes to full trial and all the discovery is done and everybody makes their arguments. So the 16-hour training, the references, all of these things, I think will be addressed. He did talk about the requirement for the fees for obtaining a CCW in New York, and how you cannot make these so expensive that the average citizen or even those of the lower income levels cannot access a concealed carry weapons permit. It's got to be available to everybody. So you can't add all of these fees to mount up to, you know, thousands of dollars in order to obtain one of these permits from New York. So clearly this judge is open to hearing arguments.
Oh, I would say so. One of the things I thought was interesting in his, again, I just had time to kind of speed read it, you know, if you want to call it that, because it's 100 and some odd,
140 pages.
Yeah, it's 100 and some odd pages long, and I didn't get all the way through it, but I did kind of scan through it and look for and highlight the things that I thought were kind of stood out. And one of the things I thought stood out, and then I looked at some of the news reporting on it. particularly one article written on bearing arms by Cam Edwards, which I thought was excellent because he picked it apart. You know, Cam, he's really good at that. And so it was interesting. In fact, I'll put the link in the description if you want to go read that article on, if you're watching this, you want to go read that article on Cam's website at Bearing Arms, you should, because he really breaks it down really well. But I thought one of the things, I don't know whether he brought it up or somebody did, and then I went back and looked for it, and that was that the judge seemed very immediately open to declaring the personal meeting requirement as unconstitutional. It's just that the plaintiff had not made, in the judge's mind, hadn't made a significant argument saying that this was really an inconvenience. Mm-hmm. And so he's kind of cueing GOA to say, you really need to, polish up your argument on this particular. I really saw this judge as really trying to give, in a roundabout way, set GOA up for success by pointing out what the argument needs to be as the case goes forward. Now, obviously, there'll be other arguments we, maybe don't foresee, but I thought that was kind of encouraging. I'm a little concerned that people are going to look at it, well, yeah, but he left the training, but he left the... Look, we got to grab the victories where they are. They're not always total victories, and this is just an injunction, and it's an injunction against the vast majority of this draconian, unconstitutional law. I would argue, and I know you would too, Sam, that the remaining items are also unconstitutional, but that's to argue in court later on.
Yep. Judge Sotheby, he pitched us a whole bunch of softballs right down the middle, and we're ready to hit them out of the park. We are already preparing for the eventuality, first of all, for an appeal to the Second Circuit with regards to suspending the injunction. And we're preparing to go to trial and argue this case in great detail. Now, GOA, GOF, and GOC, we were listed plaintiffs on the original case because the judge said that these organizations, even though you have members, you cannot be the plaintiffs on this case. So we removed ourselves from the list of plaintiffs, and we have 6 GOA members who are the actual plaintiffs who are directly affected by that. But the fact of the matter is that our organizations are still the organizations that are funding this lawsuit, that are providing the lawyers and developing the arguments on this thing. And for those people who want to sit there and pick this apart and say, oh, we didn't win, this isn't a victory unless it's a total victory, you have to remember, it's been decades that they have piled these gun control laws on our backs, and we are winning major chunks off. The fact that we only calved off a part of the iceberg and not the whole thing, is ridiculous. We're winning. We're preparing to win more. We are winning across the country, and if you want to be a part of that, you have to get involved. So. Well,
you not only carved off part of the iceberg, you didn't just carve off the tip, you carved off the majority of the iceberg. There's a little chunk of ice still floating around. The rest of it is gone. So you guys really did a great job. I want to clarify something just for you if you're viewing this, and that is what Sam's position is. You're used to seeing Sam on my show as the Gun Owners of California guy, and he is. But Sam, can you tell us, what do you do for Gun Owners of America and Gun Owners Foundation?
I am the Secretary Treasurer of the board for both Gun Owners of America and Gun Owners Foundation. So I have a responsibility over the direction of GOA and responsibility over the expenditures and the direction of Gun Owners Foundation. I have the blessing and opportunity and curse of reading every brief, every lawsuit that is filed by GOF, our legal foundation. It is immensely gratifying and educational, and has done more to help me clarify in my mind how simple and clear the Second Amendment is, and how our only option, our only direction for success is no compromise. People know that we've challenged the bump stock issue, that the Supreme Court decided not to take that case, as well as another bump stock case. But there's another case on bump stocks coming up from I believe it's Texas, that is really a good case. We're challenging the National Firearms Act of 1934. We're involved in many legal issues to restore the Second Amendment to what it means, and as described by Justice Thomas.
Well, Sam, it's just terrific news, and I wanted to make sure we got it out there, particularly given the sort of dearth of news on it, except within the very narrow frame of firearms Second Amendment advocates because of all the campaign stuff. I guess a couple of things I just want to add here, and then I'll ask you for your final thoughts are, but a couple of things here. This is possible because of elections, because you choose, in many cases, your Superior Court judges are elected. And so you got to do the research at elections to elect the right judges, not elect the ones that you don't like. At the same time, the federal judges are appointed, and they're appointed by the president, and they're confirmed by the Senate. So your vote for president is important, even if you're in California where you think it's a waste of time. And your vote for House and Senate members are important because all of this stuff plays into the way our system works and our system of government. So this whole election cycle is kind of sucked all the air out of the room, and you don't see a lot about what's going on in the courts. But there are a lot of court battles working their way through the courts, and they come up before judges. And as much as we'd like to think that the judges aren't political, many of them are. And so it's important that they're appointed by people who support the Second Amendment, support the Bill of Rights, love the country, and support the Constitution, and not activist judges who don't. That's what makes this possible. So I would urge you, and I'm sure Sam will too, if you have not already, join Gun Owners of California, whether you're in California or not. Join Gun Owners of America, regardless of where you are. Support an organization that is actually funding lawsuits and fighting for your rights, and this is a great example. And where we get a win, it's hardly ever going to be a complete and total win. That's okay. So we win 85% of it, and there's 15% left. Guess what? GOA is going to go back and fight to remove that 15%.
100%.
We're not just stopping at that point. We're going to keep going until it's all gone, until our rights are restored. Last thoughts, last word, Sam, it's all you.
So, Gun Owners of America, Gun Owners of California, we do only three things. We fight in the legislatures throughout the country and in the Congress because it's important to tell the truth when our elected officials are considering laws that affect the Second Amendment, critical activity. We work in elections because elections are important, as you pointed out. If we can elect people who support the Second Amendment, then we don't have to worry so much about what they do when they're in the legislature. They're sponsoring bills that are supporting the Second Amendment, bills like national reciprocity for CCWs across the country, removal of the ridiculous oversteps that the Bureau of Alcohol, Tobacco, and Firearms is taking with interpreting and creating law when they don't have the ability, the right, or the right to do that, and in the courts, filing the lawsuits, strategically filing the lawsuits on the right cases, and then not only the cases that we file, but supporting other lawsuits throughout the country with amicus briefs, where we add to the body of legal argument that is going before these judges. Incredibly important. We are making huge steps, huge progress, and we're not going to stop. And I want to end, Eric Pratt, our Senior Vice President for Gun Owners of America, his quote was just wonderful. Just like we warned politicians after the Bruin decision, fall in line, or we will force you to. We are excited to see Kathy Hochul finally served a plate of humble pie, and we are fully prepared to continue to fight should she again attempt to disarm the citizens of her state at a time when her party's policies are only escalating the danger that everyday citizens face. So well said. These elections are incredibly important. If things turn out the way they are projected to turn out, we have an opportunity maybe not to promote pro-gun things in Congress, but to stop all of the anti-gun things in Congress. Everybody, if you haven't voted, today's the day. Either go down to your local voting location, cast your votes, or turn in your mail-in ballots today. Get them counted. We're probably not going to know the results of many of these very close races for weeks to come because of the mail-in ballot thing, but that should not stop you from voting. And even if you are represented by anti-gun knuckleheads for Congress or U.S. Senate or state offices or governor, vote. There are so many races that are on the razor's edge right now that are literally ardent anti-gunners versus supporters of the Second Amendment. This is a critical day. Get out there and vote. And then, if you want to be a part of the process, join Gun Owners of America. Contribute to Gun Owners Foundation, totally tax-free expenditures. Support Gun Owners of California as we triangulate through our organizations in order to restore the Second Amendment to what it should be, a clear, simple right that we have that pre-existed the Constitution and the Bill of Rights.
Now, I know somebody's going to put in the comments, my vote doesn't mean anything. Okay, wait a minute, hold up. And then I'm going to wrap it up here, but I do want to share this. Some, particularly the statewide races, some of the races for the state legislatures, sometimes they're so close, they're won or lost by a handful of votes. Like, count the fingers on my hand.
Yes.
5 or 10 votes can swing these stupid things one direction or the other. So if you think your vote doesn't count, I beg to differ. It absolutely counts. If you have not voted today, please go do so. It's extremely important that you do. Thank you very much, Sam, for being on the show. I know you're super busy. Have a wonderful week and stay safe, okay?
Always wonderful to be with you, Joel. I look forward to our next meeting. Thank you. God bless.
Pleasure. Thank you very much for watching the whole interview. I'm really grateful that you do. Thank you very much for your support of GunGuyTV. Without you, I wouldn't be able to do this. And I'm very grateful for the fact that you support Sam in the work that he does at Gun Owners of California and, for that matter, Gun Owners of America and Gun Owners Foundation. You will find links in the description. Please support those organizations. If you'd like to support me, one of the best ways to do that would be jump on GunGuyTV Crew and become a GunGuyTV Crew member. You can do that with the link in the description, and that will give you access to a bunch of exclusive content you can't find anywhere else. Have a great week. Thank you very much for all of your support, and wherever you go, whatever you do, stay safe.